Welcome to the Ask a Lawyer series by Crime Sipo, where we make legal concepts simple and practical. On today's episode, we explore copyright and intellectual property for every creative. Stay tuned.
Hi, my name is Wahome Wilson. I am a technology and intellectual property lawyer. Currently running my own outfit known as GW Rifa Consulting, where we specialize in technology, intellectual property, as well as data protection.
What legal resource does a graphic designer have when a company uses their interview test work despite never hiring or paying them?
So I think I'd say that one, this is really dependent on the fine print. And it's very critical for any creative, not just graphic designers, but for any creative to go through the fine print before accepting any interview or taking part in any competition. Because if you don't go through the fine print, then you're not aware of what the consequences or ramifications will be for you submitting your work. And so if the fine print exists and if it then says that this entity has the right to use your work beyond the interview, even if you do get the job, then unfortunately, that's it. There's nothing much you can do because it's already in the terms and conditions of that competition or of that job interview. However, if there is none, then you do have legal redress and you can definitely sue them for copyright infringement because they've used your work without permission.
What are my actual rights as a creator under copyright law?
So under copyright law, the rights that a creator would enjoy would probably be grouped into 2 or 3. So the first one is what we call moral rights. So for moral rights, the biggest chunk of it can be what we describe as attribution. So attribution means Mimi, ama wewe as the creative or as the creator, you have the right to be referred to as the author or the creator of that work. You have the right not to have that work distorted, and you also have the right to have that work not be modified without your consent or without your permission. And then beyond that, you also have the economic rights. So economic rights, as basically as the word suggests, financials. So financials mean nobody can reproduce this work, nobody can perform this work in public without your consent. And then, of course, you have the third right, which would be automatic attribution. So that means create kitu under copyright. So that's a film, a song, or anything of that sort. This just means that copyright is going to accrue automatically on that work.
What can I do if someone uses my music on social media without authorization?
For social media platforms, that probably would be your TikToks, your Instagrams, your YouTubes. They're very particular on managing your copyright. And if you use an individual's work without their permission, perhaps a song, as venye umesema, what the creator would have as a remedy would be to write to the social media platform to take that content down. So in many instances, you'll find that creators, when you are on those platforms, they tend to get takedown requests so that you are requested to pull down your work because you've used another individual's work without their permission. Then, of course, beyond that, you have the legal remedies. If it is not taken down or no action is taken, you can always proceed to sue them for using works without your permission.
When a client pays for my content, do they automatically own it, or can I still reuse my work?
That depends, again, on the fine print. So is there a contract between you as the client or as the creative, basically between the two parties, as between the client and the creative? So what does the fine print say? If there is the provision to reuse that work, or if it's a sort of exclusive work that you are only allowed to produce and to use one of, that is the content of that particular contract. But if, again, there's a provision or you negotiate for use or for non-exclusivity of the content that has been produced, then, of course, beyond the engagement with this particular individual, you can go ahead and reuse the work that has been already given to the client.
How can I avoid copyright claims when using mainstream music I don't own in my content?
I would presume is on your social media platforms again, your TikToks, your Instagram, your YouTubes. So for Instagram and TikTok in particular, what happens is that during the process of uploading a video, sometimes you can incorporate an audio. And what happens is that these social media platforms, they collect the copyright on behalf of the creator. So for you to avoid any claims against you as a creator, the one thing that you must always do is attribute. So if it's a YouTube video, for instance, hapo chini, you're supposed to say that the song is by this and this. And if possible, I think you're also supposed to tag them the same. For TikTok, because it's primarily an audiovisual platform, they will take care of that side of things, so that unless you're using a new song that has not already been uploaded on TikTok, then you also have to attribute. But if they get this takedown request from the producer of the creator of the song, then as the person who has uploaded this content, you'll have to take it down.
What if I remix a song or just use one verse?
If, say, for instance, you want to use an individual song to remix it or to do something in addition to it, you will have to go and get permission from the original creator. So what this permission can look like, again, depends on the context of that conversation. So you can rendition one verse, but if it goes beyond that, then probably there might be some financials that are involved. So you probably have to sign a contract with the original creator of that song, so that if there are any royalties to be paid, then there's going to be a splitting of this royalty. So if it's just kitu kidogo, you're not doing something too significant. If it's just on your personal page and it's just for, kawaida content creation, then there shouldn't be too much of a problem simply by attributing. But if you intend to use it for economic gain, then you need to go back, enter into an arrangement with this individual, so that if he allows you to use it or a small part of it, then that's fine. Kama nataka kubwa, ama if you want to use more of the song or of their works, then there are probably going to be financials that you need to agree with this individual on.
If someone photographs my paintings and sells prints, do I have legal rights to stop them?
The answer is yes. And if you recall what we said about the rights that a creator has under copyright, one of them is economic. And of course, the second would be moral rights. So if I go and take a picture of an individual's painting and then I reproduce that work, then I am already infringing on their economic rights. So if you, as the original creator of this painting, get wind of the fact that kuna mtu mwenye anatumia my work ama ameenda akapiga picha the painting that I created, and then they are redistributing it, especially for a profit, because you see, all these things tend to come down to, are you getting any financial gain from whatever it is you're doing? If you've taken that picture, reproduce, and then you're selling it for a profit, that means you are using this original creator's work without any financial gain to him or to her. So you need to, again, so as the creator of this nini, you can institute a suit. Now say, this guy is redistributing my work, again, without your permission.
What can be trademarked, and what are the legal steps I need to take to secure a trademark?
So I think a good place to start would probably be kuelewa what a trademark is. And so, just maybe if I could use this as an example, this Dasani, so this is a brand. So what happens is that when you're trademarking something, or the essence of trademarking, and what you can trademark would be a name, a logo, a symbol. So for instance, I can decide if I feel like my name Wahome is unique enough and I'm deriving economic gain. Somebody who has done this in the recent past, I think, was Aziad alienda ka-trademark jina yake. There was also the whole issue of Willis Raburu aki-trademark the name Bazoo, so that you are not allowed to use that word without his permission. Again, it's not just in the normal conversation tukisema Bazoo na nini apana. It's again for economic gain. So if you feel like the name, the mark, the logo or symbol that you have is significant enough for it to warrant protection, then you can go ahead and do what we call, you trademark it at the Kenya Industrial Property Institute, which is located somewhere along Waiyaki Way. And so maybe just to give like a very quick process of what trademarking looks like, you will carry out what we call a search, kwa sababu the registry kuna trademarks mingi sana. And so you need to conduct a search ndio ujue, is it unique enough for it to warrant registration? So once umepata the search results, the registrar atakwambia, this one is good to go, ama you can't register it, because sometimes they can also be generic things. For instance, unajua sasa nikienda tu niseme I want to trademark this bottle of water, nataka kuita maji mzuri. You get that it's not unique enough for it to warrant trademark protection. So once you do the search, you'll get the results. After that, you proceed to registration, to apply for registration. Once registration goes through, it is advertised in the Kipi Journal, and this takes about 60 days or 2 months. And if anybody has any complaint, because this journal is meant to be for the public's consumption, so mtu ataenda angalia hapo, aone kuna mtu mwenye anataka kuregister trademark yenye inafanana na yangu, and probably the registrar did not see it at that particular point. Or if you feel like this one is not creative enough for it to warrant trademark protection. So if it goes through the trademark registration journal without anybody raising any issues, then the last step would be for you to get your trademark certificate. So that is a very condensed process of what trademark registration looks like.
For an ad. How do I avoid copyright issues and potential lawsuits?
So you want to use a song for an ad. And I think I'd say I'd look at it again from two scenarios. One, if you are using social media platforms, again, for instance, TikTok is a very good example because, as we said, it's an audiovisual platform. And as we said, TikTok tends to handle the legal side of things, so that all songs that have been uploaded on TikTok, the creators are already okay with you using their song for any particular purpose. So umeenda umetengeneza video ya TikTok and you've used a song that is already on TikTok, then that's okay. There should be no problem because, as we said, TikTok already handles the legal side of things. But say, for instance, you're doing an ad, and this ad, you're not doing it on any social media platform, as in you're not using a social media platform like TikTok as a good example. Unaifanya tu kivyako, umekuja hapa, umesema we want to do an ad, so do that. Then again, that would require you to get in touch with the creator of this work so that you can agree on what royalties are due to him, because it's a contractual arrangement. This artist feels like this is a very massive song, or it's a very popular song at the moment, and so therefore they want to list it to you or to give it to you for a specific fee. So again, it's just that then boils down to maneno a contractual arrangement. It's just kuelewana figures, and then once you agree on that, then you should be good to go to use your work for your advertisement as a company.
A creator remixed my podcast clip into a meme without my permission. Is this actionable?
I think I said that that's a tricky one. One is because that falls under the realm of copyright. Copyright, and copyright is consistently evolving, and how it has evolved. It's a very long story, but where we are currently is on the use of memes, for instance, because what will happen is that somebody will take a sound bite and then they will incorporate other videos and whatnot, and then it changes very quickly. And so there's a concept in copyright that is called fair use. So fair use means nimechukua a work that you have, and then I have gone and I have made significant amendments. So I've used yours as inspiration, for instance. Nimechukua, whether it's a song, it's a painting, it's a picture, or whatever. Nimeenda and I have made significant changes or amendments to it, and now it is almost completely different from what was originally created. So it is arguable that hata mimi kitu yenye nimetengeneza, it is very unique from what originally existed. So in that particular context, that would probably be where memes fall, kwa sababu mtu anaenda anachukua whether it's a song, a clip, or something else, and then you modify it ama una change, and it becomes almost entirely unrecognizable from what it originally was. And so the original creator of this song or this painting or the original work basically anaweza kuja na anaweza sema ulitumia kazi yangu na kuremix na kufanya hizi vitu zingine zote, but you see, I would then argue fair use. Nimekuja and I have added significant value to the original work that existed. So it's very difficult for the original creator to say it's no longer is yours. It has taken on a whole new appearance. So there might be action, but again, it depends on what, if you go to court, they will assess it as, does this fall under the realm of fair use? Has it been changed or has it been altered significantly enough for you to say, imebadilika, ama does it still bear many resemblances to the original work? So it's a balance to say.
If someone uses AI to mimic my art style and even uses my color palette to create similar work, is there any legal action I can take?
So that then goes back to the concept of fair use that we are saying. So sometimes it's actually a very difficult need to decipher, kwa sababu sasa you've used this as inspiration, and I wish this was a class so that I could show you what I'm actually saying. So there's a picture ilitakiwa of Barack Obama, and there was a whole suit that emerged from this, because there was the original picture of Barack Obama, and then somebody took that picture. They made significant amendments. I think it had the "Yes We Can" chant. Akakuja kaibadilisha. I think they inserted the American colors. Nini. So when you are going to court and you're arguing that this is the picture I took and this is the picture that now exists, so what are the changes that have been made? Na imebadilishwa kiasi gani? Ama has this guy who has then made these changes contributed significantly to making this work a work of art, for instance? Like ameibadilisha na mtu akiona aseme hii inakaa poa sana, like this really looks good, like this is the original but this also looks really good. And the thing about copyright is that you have to expend some work. Kama umeifanyia kazi, like umekuja umechange, hata kama you're running it through, maybe AI is not the best example, but kwa mfano for instance uchukue uingie Photoshop, si ndio, umake changes, ufanye all these other things that will then create something that is entirely different from what was originally intended and what was originally created, then it means that you fairly used it. Kuna the concept that we call fair use, that then it's a defense that is used. Mtu akikuja aseme umetumia waki yangu kutengeneza hii waki yako, but you can argue fair use. So I think that's how I'd say it. But the flip side of it inakuanga that sometimes copyright can also be, I don't know if you guys know or the kitu inaitango riffs. So unaweza chukua riff kama for instance Sauti Sol and their Midnight Train, whichever song you want to pick. Ukichukua tu a small sample of that song alafu itumie as is, it doesn't matter whether it is 1 second or 2 seconds, but as long as it is a very recognizable sound na umeitumia tu as is, you've not remixed, you've not added any significant value to that work, so it doesn't matter. Hata kama it's a second or two, you can still sue as the original creator of that work because you are taking what we call the essence of that work. That's fair use versus you taking or sampling something that might probably be deemed to be very small, but which is the essence of this individual's work.
And that is all from today's episode of the Ask a Lawyer series. Share your thoughts in the comment section and stay tuned for the next episode. Keep it crime, see poor.